Welcome to Human Rights Law class. This is a class on Article 4, Absolute Right, Freedom from Slavery, and it's about understanding the absolute prohibition on slavery and forced labour in modern human rights law. My name is Nisir Hafizi. I am a solicitor and senior lecturer. Welcome to class. The learning outcomes for this class are 1, to explain the absolute nature and fundamental principles of Article 4 of the European Convention on Human Rights. 2, to understand what constitutes a breach of Article 4 and what does not. 3, identify the various forms of modern slavery and forced labour, including human trafficking and domestic servitude. And 4, analyse the legal obligations of states under Article 4 and the challenges in its effective implementation. As always, there are true and false questions and single best answer questions. So this is the true and false questions. There are 10 of these, and you'll find the answers at the end. 1. True or false? Article 4 of the European Convention on Human Rights prohibits slavery, servitude, and forced or compulsory labour. Question 2. True or false? Article 4 is an absolute right and allows no exceptions under any circumstances. Question 3. True or false? Work required in the ordinary course of lawful detention may fall outside the definition of forced labour under Article 4. Question 4. True or false? Compulsory military service may constitute forced labour under Article 4 in all circumstances. Question 5. True or false? Servitude involves a situation where a person is legally owned by another individual. Question 6. True or false? In Van der Mussel versus Belgium 1984, the European Court of Human Rights held that requiring trainee lawyers to provide unpaid legal services amounted to forced labour. Question 7. True or false? When assessing whether work amounts to forced labour, the court may consider factors such as the nature of the work, the level of hardship involved, and any penalties imposed for refusal. Question 8. True or false? In Riley versus Secretary of State for Work and Pensions 2013, the Supreme Court found that mandatory unpaid work experience for job seekers allowance claimants breached Article 4. Question 9. True or false? The European Court of Human Rights has recognised human trafficking as falling within the scope of Article 4. And question 10. True or false? Article 4 imposes positive obligations on states to prevent slavery and investigate potential trafficking cases. And then there are 3 single best answer questions. Question 1 is: a migrant worker is forced to work long hours in a private household without pay. The employer confiscates the worker's passport, prevents them from leaving the property, and threatens violence if they attempt to escape. Which of the following best describes the potential Article 4 violation? A breach of Article 4 because the individual is being subject to forced labour only. B, a breach of Article 4 because the individual may be subject to servitude or slavery. C, no breach of Article 4 because the individual agreed to work for the employer. D, no breach of Article 4 because the situation involves a private individual rather than the state. Or is it E, a breach of Article 4 only if the worker is a citizen of the state? Question 2 is: James is serving a lawful prison sentence. As part of the prison regime, he is required to perform daily cleaning duties in the prison workshop. Which of the following best reflects the legal position under Article 4? Is it A, this automatically constitutes forced labour under Article 4? B, this constitutes slavery under Article 4? C, work performed in the ordinary course of lawful detention is excluded from the definition of forced labour? D, prisoners may only be required to work if they receive payment? Or E, Article 4 does not apply to prisoners? Single best answer question 3. A young woman is trafficked into a European country and forced to work in exploitative conditions. The authorities receive credible information about the trafficking network but fail to investigate or take protective measures. Which principle of Article 4 is most relevant? Is it A, Article 4 applies only where the state directly enslaves the individuals? B, Article 4 imposes positive obligations on states to prevent trafficking and investigate exploitation? Is it C, Article 4 applies only to historical forms of slavery? Is it D, Article 4 applies only to citizens of the state? Or is it E, Article 4 does not cover human trafficking? And you'll find the answer to all of these single best answer questions at the end of the class. The historical context of this particular article is found in World War II, but even prior to that as well. Although slavery was abolished in most parts of the world in the 19th century, Article 4 responds directly to the horrors in World War II between 1935 and 1945. Nazi Germany used millions of people from across Europe to carry out forced labour in support of the Nazi war machine, demonstrating the urgent need for absolute protection against such exploitation. Article 4, the absolute proposition. So it's developed in this context in the 1940s and 50s. Article 4 of the European Convention on Human Rights establishes a fundamental protection against slavery and forced labour. The prohibition is absolute with no exceptions or derogations permitted. No one shall be held in slavery or servitude, Article 4.1. No one shall be required to perform forced or compulsory labour, Article 4.2. For the purposes of this article, the term forced or compulsory labour shall not include a. Any work required to be done in the ordinary course of detention, imposed according to the provisions of Article 5 of the Convention, or during conditional release from such detention. B. Any service of a military character or in case of conscientious objectors in countries where they are recognised, service exacted instead of compulsory military service. C. Any service exacted in case of an emergency or calamity threatening the life or well-being of the community. And D. Any work or service which forms part of normal civic obligations. You can see from Article 4.3 specifies that certain forms of work do not constitute forced or compulsory labour. Prison labour is an example, work ordinarily done by convicted prisoners as part of their sentence. Military service, compulsory military service in European countries that maintain the system. Emergency work required during emergencies or calamities threatening community well-being. And civic obligations, work or service forming part of normal civic duties. It's important to define certain terms. So slavery is defined by the 1926 Slavery Convention as the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. The European Court of Human Rights has accepted this internationally recognised definition. And there's also servitude. A person is in servitude, is not owned by another. So is not a slave, but includes an obligation to live on another's property with an inability to change that condition. It's distinguished from slavery by the absence of ownership rights. The meaning of forced labour was found in the case of Van der Mussel case. This is the case of Belgium trainee lawyers. The European Court of Human Rights considered the meaning of forced labour in this case involving Belgium trainee lawyers required to work for poor clients without pay. Was this a breach of Article 4.2? Article 4.2, no one shall be required to perform forced or compulsory labour. Now, the context matters. The court examined the requirements within its proper context. Professional development. Trainees gained valuable experience whilst qualifying for their profession, so the court found there was no breach. Forced labour was work or services that person was forced to do against their will. The work didn't prevent trainees from also doing paid work for other clients. Quite a harsh result. Testing for forced labour. The court established that forced labour is work an individual is compelled to do against their will. A range of circumstances must be considered: the type of work, the penalties or burden, and the level of hardship. The type of work, the nature and character of the work being performed, penalty or burden, consequences imposed if the work is not carried out, and the level of hardship, the degree of oppression to which the individual is subjected. Interpreting forced labour was further considered in the case of Riley versus Secretary of State for Work and Pensions 2013. The facts in this case are basically these. This was a challenge to the requirement that a person in receipt of the state benefit called Job Seekers Allowance had to carry out unpaid work experience as a condition of continuing to receive this benefit. It was held that the Supreme Court found that this requirement did not breach Article 4. The court said that an essential element of forced labour was that the individual had to be exploited, and that requirement was not met here. Modern slavery and human trafficking is a big issue. Slavery still affects millions worldwide. Human trafficking involves recruitment or movement of people for exploitation through threat, force, fraud, or abuse of vulnerability. In This particular case of Rancet versus Cyprus, the European Court of Human Rights confirmed that human trafficking falls within Article 4, creating positive obligations for the state to enact and enforce anti-trafficking laws, to take operational measures to protect victims, and to investigate potential trafficking situations. So going back to the true and false questions, you can see the questions there. And if you pause it, you'll be able to see what the answers are on the next slide. Check here. Hope you got them right. And then there's now a series of single best answer questions with their answers. This is the first two single best answer questions. Feel free to pause and check the next slide for the answer. This is the answer to question 1 with an explanation. Question 2 with answer and an explanation. And finally, question 3. Feel free to pause it, read it, and check your answer with the next slide. And hopefully you got that right. So just a couple of key takeaways. It's an absolute prohibition. The prohibition on slavery and forced labour is absolute with no exceptions. There's clear definitions. Terms have been clarified by the European Court of Human Rights through landmark cases. And state obligations, Articles 2 to 4, impose positive obligations on states to prevent breaches and investigate alleged violations. Hope you found this class useful and interesting. I hope to join you for the next class. Feel free to subscribe if you haven't already, like the video, and feel free to comment also. And see you in the next class.